remember the Dependents Conference division of the South African Council of Churches. So this is where I was employed. The Dependents Conference back in the day rendered assistance to persons accused of politically motivated offences, ensured that bail applications were brought as soon as possible, made sure that there was legal representation when people went on trial. And then there was also a grant system which was administered for families where a breadwinner was imprisoned. That in a nutshell, it went a bit more than that, CJ, but I think that's in a nutshell what the activities were about.
Yeah. A good place for young men to venture into the working world.
Will you please just repeat that, CJ?
No, I was saying a good place for a young man to venture into the working world.
CJ, I don't think it was always that good.
Yeah, I can imagine.
It was quite trying times and circumstances under which
we know what kind of work the Council of Churches did. All right. So in 1987, you went and did your articles with Abercrombie and Son attorneys.
That's correct, CJ.
And then in 1989, you became an associate. What happened? I see that it was a change of partnership. I see Abercrombie is still there, but it's Wilkinson and Kiwala, Joshua and Abercrombie.
Yes, CJ, I did my articles with Abercrombie and Son, then qualified as an attorney in 1989. But by that time, there was a merger between Abercrombie and Son and a firm called Wilkinson, Joshua and Kiwala. And thereafter, you will see from my CV, CJ, that I then went through, I've never left the firm at which I started my articles. That firm went through various mergers until I finally am where I am now.
So you became a director in September 1989, and then I imagine there was another measure because it became of Mayor Hepstein, no, it's Kiwala, and
Yes.
you were a director in that firm as well for about 10 years?
CJ, I was quite lucky. I was admitted on 16th of May 1989, and by 1st of September 1989, I was appointed as a director in the firm, Wilkinson, Joshua, Kiwala and Abercrombie. We then existed as a firm until 1997 when we had a merger with Mayor Epstein's, and then became of Mayor Epstein's Kiwala. That firm lasted from 1997 until 1st of September 2008. We had yet another merger with Cliff Decker, and this is how we are currently still constituted, Cliff Decker Hofmeyer, CDH.
And as you say, you remained there throughout this evolution.
Yes, CJ.
And now you're executive consultant since 2019.
Yes, indeed so,
All
CJ.
right. You are an NADEL member since 1987. NADEL.
Yes, when I joined Abercrombie and Son in 1987 for articles, my principals, the late Percy Son, Alex Abercrombie, were founder members of NADEL, and basically all the professionals in that firm, including we were called article clerks back in the day, then became members of NADEL, CJ.
Yeah. It's mentioned here that you are an admitted legal practitioner in Namibia.
Yes, CJ.
Do you practice there as well? What is the setup?
That's an interesting story. I applied for an admission as an attorney in Namibia in 1990 because Post the Namibian independence, there was a window period during which lawyers who are qualified in SA who could apply for admission in Namibia. And in fact, all our partners made those applications back in the day. But it was an admission that remained dormant, if I can call it that, until 2024 when there was a need for a person in CDH, because we opened up a branch in Namibia, CJ. And I then was, because I am admitted to practice in Namibia, was then actually the founding partner of our Namibia office. But I don't practice there, CJ. I am based in South Africa.
All right. You say in your application form that the earlier part of your career was dominated by work in the areas of criminal law, administration of deceased estates, and matrimonial law. Then, as the firm became bigger, you were exposed to a greater variety of work, and you did personal injury law, insurance law, and general commercial litigation. What
Indeed.
are you doing at the moment? Because you say here you relinquished personal injury work in 2014 and you're doing another type of work.
CJ, I currently practice as a specialist insurance lawyer. That is my area of special interest. But because CDH is a large commercial law firm, I also do general commercial litigation. I form part of a team in our dispute resolution department or litigation department, is commonly known. And that team is spread across the Cape Town office and the Johannesburg office. So it's quite a large team. And in that team, I participate in general commercial litigation as well, which will entail the entire spectrum. We do a lot of motion work here in Johannesburg as well as in Cape Town. Like I said, my main area of specialization is insurance law, but I'm not confined to insurance law only. I do a fair amount of general commercial litigation.
And in the midst of running a busy practice, you've managed to publish or co-author a number of legal articles on a, as I see it, on a wide range of legal subjects.
Mainly in the insurance domain, yes, CJ,
You've written on medical negligence as well.
etc.
And interestingly, you wrote on the Uber revolution.
Yes. Yes, that was a very interesting, I did an opinion for them and they gave me permission to publish an article around that.
That's interesting. Okay, so you have experience, judicial experience. You've acted in the High Court.
Yes, CJ, I completed 2 terms in the Western Cape High Court. The first was during 2024, first term of 2024, and then I did a second term at the end of 2025. I am currently again serving a term. The term commenced Monday, and I was appointed for the entire term, CJ.
All right. So what kind of cases have you dealt with?
CJ, during my first term, I dealt with a vast amount of opposed motion work. The Western Cape division has quite large volumes of opposed motion work. So I dealt with it and obviously had to do my motion court duty week where you do urgent duty, etc. I have now also, if I take my second term into account as well, I've presided over several trials. There is still a parted action, civil trial. I've presided over civil appeals where there was one judge with me. I presided over criminal appeals, quite a few of them, one of which was a full bench appeal, which concerned bail essentially. But CJ, I have not yet done a criminal trial in the High Court.
I was going to ask that. So your exposure to criminal law has been quite limited.
CJ, I won't say that. In the beginning part of my career, I did quite a lot of criminal work in the magistrates court and in the regional courts.
Because
I have subsequently, over the past few years, because I find myself in a commercial law firm, criminal law isn't an offering as such, service offering as such. But where some of our commercial clients require assistance with criminal matters, then we render that assistance. And I would normally the person attending there too. So it is really not foreign to me at all.
you've listed a number of judgments you have written. How many in all would you say you have written?
CJ, over my two terms, I've written around 32 to 34, 36 perhaps judgments. Or delivered that amount of judgments. I looked at it the other day, and it appears to me that I have written judgments comprising around 32, and then I've also done 4 extempore judgments.
I think I'm going to stop here for now. The issues I want to raise with you may well be raised by the other commissioners. I'll see at the end of the round where we stand. And now I'm going to hand over to JP Mabindla Pokon with questions to you if she has any.
Good evening, Mr. J and fellow commissioners. Thank you. Good evening, Mr. Barnes.
Good evening,
How
JP.
How are you doing today?
I think I'm doing quite well, JP. And how are you doing today?
All right, I'm also well. You have acted in the division for 20 weeks. It will be 20 weeks, actually, if we include this coming term.
Yes, JP.
And how have you found your acting stint and the environment in the division?
I must say that when I did my first, as would be expected, my first weeks was a question of finding your feet, getting to know what being on the bench is all about. But I settled into that role very quickly, to my own surprise. And maybe it was because I attended the training course for aspirant judges. In fact,
Yes, that's what I was going to ask you, that you didn't mention that you actually attended the aspirant judges course as well. And why did you find the need to do that? And what did you learn from there?
I was going to do my first stint in January 2024. I saw the opportunity, and I always had these thoughts about practical day-to-day things that would maybe be part of a judge's life that you would not know if you just walk into that role cold. And I am really so pleased that I attended that training course, JP. Something like how to manage your bench book, for example. I don't know how judges who normally just, I suppose you do get some guidance from colleagues and maybe from your secretary and so forth. But those were very useful things, and the training course was of a very, very good standard. There are things that you would probably learn the hard way unless you attend sessions like that. Things like limiting the amount of parties meeting in your office. We were encouraged to have our secretaries present, for example, where you do have meetings with parties in your office. simply so that if at a later stage disputes arise, then you at least have somebody who can back you up when people put words in your mouth.
Your firm has done some pro bono work, and can you tell us more about that?
Yes, JP, we have a large pro bono department. As recently as, I think, a month ago or so, but definitely during this year, our pro bono team also participated in the CREDOC 4 inquest. In fact, we've been involved in that inquest for quite a number of years. But over and above that, there is also a general pro bono work where our pro bono department will from time to time release articles around the type of work that they are doing. And it is really quite, I think, heartwarming to know that the firm, given my background, it really makes me feel very comfortable that the firm is doing this, the pro bono work to the extent that it's doing it.
Our court receives a fair amount of administrative law and constitutional law work. So what would you say if someone says the fact that you have limited amount of experience, you're not ready yet, and you need to be given more acting stints at the court? What would you say to that?
I would say that I am more than ready, JP. The reality is that any person who steps into a new role will have to grow. The amount of growth required will differ from person to person. The time that it will take you to develop will also differ from person to person. But I think with my 37, May this year, I will be an admitted attorney with experience of 37 years. I've done a vast amount of high court work, and although I never held myself out to be a public and administrative law expert, simply because in my firm I am marketed as an insurance specialist, I've done a fair amount of administrative law work. In fact, I've been involved in quite high-profile review applications, which included a self-review under the principle of legality by a huge organ of state. I've done some administrative law work for the municipalities, for 2 municipalities in the Western Cape, which concerned building plan approvals. I did work under bylaws, municipal planning bylaws, concerning building plan approvals, the erection of cell phone towers, zoning issues, etc.
Okay. You're speaking about self-reviews, so I must ask you that question. Which pathway would be applicable when an organ of state wants to review its own decision?
JPA, an organ of state, will then have to rely on the Constitution and do what we call a self-review. If it wants to achieve that goal, it cannot rely on PAJA.
Yes. What should it rely on if it can't rely on PAJA?
The PAJA is on the principle of subsidiarity. The Constitution makes provision or contains provisions, I think it's section 33, around the requirements for administrative action. And it also directed the formation or the enactment of legislation for that purpose. One of it would be to ensure that there is fair administration. Now, that administrative body would be, in terms of the provisions within PAJA, would be the body whose administrative actions would be reviewable under PAJA. It is not there for that body itself to invoke the provisions to review its own administrative actions.
Okay, I'm going to another question. I've read your judgments, and I think you write very, very well and very clearly.
Thank you, Chair.
After even says that after Gauteng, they say that your judgments demonstrate thorough factual analysis, and particularly notable is your application of the Mashongwa constitutional framework in a rail passenger injury case. There is a case that you've included in your pack, Sea Pride processes, in which you sat with a senior colleague, and it was against an order by an appeal against an order to stay eviction by a magistrate. It dealt with evictions. In motion courts, we often deal with PI applications that are unopposed or people are not represented. In many cases, on the papers, you would find that a case is made that the occupants might be in unlawful occupation. What is the approach that the court should take in those instances? The matter is not opposed, or people are not represented, and they may appear to be in unlawful occupation. What is the approach that the court should follow in those instances?
JP, once you have established that a person is, technically speaking, an unlawful occupant, it doesn't end there. You are clothed with the judicial responsibility to consider all circumstances when deciding on a remedy that is just and equitable. I have dealt with quite a few of those applications during my 2 stints, and in most of those cases, your respondent or your occupier would be an unrepresented person, and it was so important to ensure that they are at court, that they are given an audience. I recall a recent matter during last year where, and it was not in the papers because the respondents never filed papers. They didn't have resources to oppose, etc. And when they appeared in court on the day, it was a couple, man and woman. I assume they were married, but there was an 8-month-old baby that formed part of that household. And it was unconscionable to, in those circumstances, issue an eviction order, even though if you take a legalistic approach, you probably would have been legally correct in doing so. But in that instance, I postponed that matter for a period of time. I think it was something like 6 months, to enable them to find alternative accommodation. There's even the prospect of the man in the house perhaps finding a job. So that's the kind of approach that one will take, because you must always be aware of the constitutional imperatives.
Okay, you've dealt with cases, delict matters. Courts are often accused of confusing or not dealing with separately with wrongfulness and negligence when reasoning. What do you understand the difference to be between wrongfulness and negligence? I know that you've dealt with this in some of your judgments. Can you tell us what's the difference between those elements and how you treat them in your reasoning?
JP, a delict has a number of elements, and negligence and wrongfulness would be some of those elements. There would have to be an act or omission, and that act or omission must be negligent. Now, negligence is normally established with reference to what we call the reasonable man test, which is very, very old law in South Africa, the so-called Kruger versus Coetzee test, where you ask the question whether a reasonable person in the position of the person who was now alleged to have been negligent would have foreseen as a reasonable possibility that harm may follow from this act or omission. And the second rider to that is that this person, reasonable person, which is a hypothetical person, would have taken steps to guard against the harm that may follow on this negligent act, on this act or omission. And if the answer is that the reasonable person would have foreseen harm and would have taken steps, then that conduct or omission would constitute negligence. But that is but one element. If you are negligent, you are not necessarily, that negligence is not necessarily wrongful. And for negligence to give rise to liability, civil liability, you need to have all those elements of the delicti present. Wrongfulness would then be the test as to whether it is within the convictions of society, whether our society would expect that this person should be held liable for this act or omission. And that conviction of society, fortunately, post our constitutional democracy, one can emphatically say that the convictions of our society, of our community, are mirrored by our constitution. So one will then look as to whether the community, our society, would expect for that negligent act or omission to have consequences in the form of liability. It is not always that negligence would necessarily attract liability, because if the finding is that there was no wrongfulness, then there is no liability.
Can I still ask questions, Jay? Okay. All right. Our court is losing experience at the moment, and we're still going to continue losing experience. Can you tell us what contribution or special trait you're bringing to the court to fill that capacity?
JP, the evolution of my practice when I embarked on civil litigation as my main area of law had this route that started with under the old Multilateral Motor Vehicle Accidents Fund Act, when insurance companies still manage the claims arising from motor vehicle accidents. At that point in time, I was representing a large insurer. Then later came the Road Accident Fund, which was established during 1997. And because I did that work for an insurer, I was then appointed to the panel of attorneys for the Road Accident Fund, and I acted for that body for a period of 16 years. JP, during that period, we all know the RAF is a very prominent litigant in all our courts countrywide. During that period, I did high court litigation in good volumes. It is fair to say that we were in and out of court all the time. In that process, I've really become quite experienced in the setting of knowing civil law and procedure. And I think that my elevation to the Western Cape bench will be valuable in the sense that while I'm in my acting stints, I can see that this judicial case management system is really achieving results. I believe that given that long deep experience with that area of the law, I will definitely be able to make valuable contributions in that regard. I still believe that some of those cases need not even reach set down stage. And yeah, I think that's one area in which I will certainly be able to make a valuable contribution. But JP, also just in general, it is my belief that any institution, even a corporate entity like the law firm that I'm currently part of, always needs a fair balance between youth and experience. In fact, we have at the stage been advised in our firm that we were a bit thin on what they call grey hairs because of that critical need in during times of crises or challenges. It is always good to have old and wise people around, and I'm going to call myself old, maybe to my detriment, but to have experience and wisdom around. And I think that if we take a peek into the future, a few senior judges will probably retire in the short term. We have seen a few retirements already, and I am willing to serve for the 12 years that are left, within which I will be allowed to serve. And I think, not I think, I think I must put it stronger than that, JP. I know that in that capacity, I will play an important role.
Okay. Thanks, CJ. I have two others, but I thought maybe I should end there.
Some of us have had a really long day, and you still have another candidate to call. Advocate Boshoff, do you have any questions for the candidate?
Thank you, CJ. Mr. Barnes.
Good evening, Commissioner Boshoff.
So the JP's already asked you quite a few technical questions, so I won't ask too many more. I just, the division is quite heavy on administrative law, given where it's located. So I just want to ask you a question that's coming up more and more, and most recently the SCA had to deal with the question regarding the so-called Bait Bridge fence, the SIU case, where the tender was set aside and the SCA had to deal with the question of just and equitable relief or compensation being sought by the service provider, because on the facts, the fence, well, that there was at least in part delivery. So what do you understand under the so-called no loss, no gain principle within the context of just and equitable relief as contemplated in Section 172 of the Constitution, and specifically within the context of irregular administrative decisions?
Commissioner, when an administrative act is set aside, the court is then enjoined to consider a remedy that is just and equitable in those circumstances. The loss, no gain, and I want to preface this by saying that I did not read that particular SCA judgment that you have referred to. But I think on application of the general principles, when deciding on a just and equitable remedy in a particular setting, that remedy that is ultimately decided upon will not necessarily entail restoration of any kind. I don't know if that answers your question. Because
So,
the court has, when it grants the relief, That relief in many instances will be accompanied by an award, a payment of compensation. We've seen that as part of just and equitable remedy, courts could allow the party whose administrative act was set aside to in fact or pay compensation to parties. Where and I'm trying to answer the question at a factual level. So the no loss, no gain type of setting, I would imagine would be a typical scenario where the administrative action is being set aside, but there is no award made because there was neither a loss nor a gain, which could play itself out. Hypothetically or theoretically in quite a number of these review applications when.
Yeah, because you see, there's in these, often with these matters, and I mean, forget about the case itself, but often with administrative decisions, especially within the supply chain space, where contracts eventually set aside either by a disgruntled bidder or by a self-review, the question inevitably arises, especially when it's a year or two deep and there has been some performance at least. There's this strain between possible enrichment by the state because of through an unlawful action, but also then should somebody that has benefited from an unlawful decision profit? And so how should a court balance that issue within the context of just and equitable relief?
When that discretion is exercised, it would be a normal principle in administrative law that no party should benefit from unlawfulness. I know that there is established case law on that principle. But one could never be that simplistic because you could deal with a situation where this party that theoretically benefited from an unlawful administrative act had no degree of wrongdoing, for lack of a better term. So you will need to go and look at whether there was complicity and what the nature of that party's conduct was. Because if that party is itself not entirely clean, for lack of a better term, then surely all gains received should be denied.
Thank you, CJ. I'm not just going to go further. Thank you.
Good evening, Mr. Barrett, sir.
Good evening.
Thank you. Yeah, just want to clear up one thing with you, which is a disclosure that you have made in your form.
Yes.
Yeah,
Yes, Commissioner.
because you might be accused of sweeping things under the carpet. Just want you to give you an opportunity to respond to this disclosure. Just explain the circumstances and what is the outcome there. Thank you.
I have fortunately obtained, and I think that should put that issue to bed for once and for all, a letter from the NPA Monday or Tuesday evening, I think it could have been Monday evening, just confirming that there really is nothing, never was anything there, Commissioner.
Put the letter. Just repeat that.
I'm saying that I have, on that issue that
Yes.
I've disclosed,
Yes.
I have obtained Monday evening a letter from the NPA confirming that there was never anything there on my part, and and that there is nothing. And I am saying that I hope that letter will put that issue to bed, because I have seen the concerns legitimately raised by
The LC
BLA.
and the
Yes.
LCSA.
Yes.
I think it was BLA and I think Nadel made
The Law
reference to that.
Society.
LSSA, yes.
I'm not sure whether the LSSA also raised anything, but yes, and that letter was then made available to the Commission, and I sincerely trust that it forms part of these records. I've also, in the interest of openness, when I obtained this letter from the NPA, I took the liberty of attaching the affidavit which I submitted to them during December 2021 to address this whole issue. And that should also be within the documents.
Thank you.
Would you be able to make that letter available to the JSC Secretariat? Would you furnish us with a copy of that letter through the JSC Secretariat? The letter from the NPA, that is.
I have done so, JP. I emailed that letter probably 9 o'clock in the evening, Monday past. I would gladly make another copy available if necessary.
No. You receive it? Okay. No, we'll sort it out internally. They confirmed that they did receive it.
Please just let me know, CJ. I have it handy. If necessary, I can just forward it again.
Thank you, Mr. Burns. Any further questions for the candidates, colleagues? DP Zondi?
Good afternoon. Good evening. Good evening, Mr. Parents. We've been sitting here since this morning. Advocate also asked you about the no gain, no loss principle within the Advocate also asked you about the application of the no gain, no loss principle within the context of administrative law when a tender is set aside. I was not sure of your answer. How does it apply? Let's say that there is an application to review and set aside the tender, and the tender is set aside. And then now we have to, within the context of Section 172B of the Constitution, it's what is a just and equitable remedy. So that is where now we have to look at this principle of no gain, no loss. How does it, I wasn't sure of your explanation of how it applies when you consider the just and equitable remedy in terms of Section 172 of the Constitution.
Commissioner, the crux of my answer was that where the tender has been set aside, where a party unduly benefited from this unlawfulness, first of all, the principle would be that nobody should benefit from unlawful conduct, which I then said is settled law. But on the specific setting of the question, my answer was that one would potentially, where a party benefited from this unlawfulness, it will be necessary to go and look at that party's conduct as well, in the context of how the unlawful administrative action came about in the first place. And when you then exercise your discretion, the decision as to whether or not to allow a party to retain any gains would then be taken in that context. I don't know if it sounds any clearer now. And I did say that this specific case, and I know that the question is based on a specific SCA judgment, which I did not consider for purposes of my interview. I'll be upfront with that. trying to answer the question on general principles.
All right, thank you. Thank you, CJ.
Thank you, TP. Anyone else, commissioners? Commissioner Moiman?
Thank you, CJ. Good evening, Mr. Barrense.
Good evening, Commissioner.
Just one from my side. Looking back at the acting stint that we had in 2024 and 2025, are there any decisions that you would now approach differently given the experience that you have had at the level of the acting stint?
In any of my judgments,
Yes.
Commissioner, I cannot emphatically say that when I look at some of my judgments, even when I did so for purposes of my interview, that I ever came to the conclusion that maybe I missed something important here. So the answer is no, but I do not deny the fact that one will continue to grow in this role always, and that there will always be room for improvement.
Thank you, Mr. Barnes. Thank you, CJ.
Commissioner Posoro.
Thank you, Chief Justice. I just want to confirm. Good evening, Mr. Barnes.
I am just trying to see where the question comes from.
She's over here.
Okay.
The acoustics are terrible here.
This room doesn't look this big on television.
Yes, good evening, Mr. Barnes.
Good evening.
I just want to confirm, you said you have acted for 2 terms.
I have, yes.
And is that sufficient time for you now to be elevated to the bench? Don't you think perhaps you need more time so that you gain more experience in the fields that have been identified, which you said you had not come across?
This question is coming from the minister. I just want to make sure, because I don't want to call the minister.
No, it's not me, not yet. It's the commissioner next to me, Advocate Poswa Lorotoli.
From here, it looked differently. I would really, with a great measure of confidence, say that I am ready for a permanent appointment. Yes, and I've mentioned it earlier on, I think even a person who had 20 stints on the bench may even still need to grow in some respects. But none of the work that I've encountered so far ever felt beyond my capabilities. And Commissioner, I firmly believe that I do not need to postpone my hopes to be elevated to the bench for another year, for example. I don't know what 2 extra terms, for example, in which way that would benefit me. And one must bear in mind that I am currently acting and will be doing so for a full term.
Thank you. Are you aware of the anti-sexual harassment policy?
I am indeed aware thereof.
Have you acquainted yourself with it?
I've done so, Commissioner.
Do you subscribe to the policy in its current form?
I actually do. I can comment that when looking at the policy and comparing this policy to policies out there in the corporate sphere, there are remarkable similarities in the type of conduct that under this policy would be defined as sexual harassment. But what I would say is, and it's also just from experience, because I've seen and being party to previous policies, I think it is reading a policy is one thing. It is necessary to actually workshop those policies, and in our firm we've had probably around 4 of those workshops just on our own policy, because you need and preferable specialists in that particular, which is normally be in the employment space. With reference to case studies, explain what it means, for example, when there's a definition of unwelcome sexual advances, etc. The definition is quite wide, and I don't think by reading the policy alone that all people who must abide by that policy will necessarily grasp the full implications. I know that there will be webinars presented on this, and one will see whether those webinars are quite detailed and in-depth enough, or whether one would need a bit of ongoing workshopping around it. But the policy as it stands cannot be criticized.
Thank you, Chief Justice.
Thank you, Commissioner. Also, Minister. Thank you very much, CJ. Good evening, Mr. Baransa. This side, it's Mina,
Good evening.
the Minister. I just one question from my side. I just looked through your resume and noticed that part of the work that you do, it's in terms of commercial work, exposure to commercial law, which majority of previously disadvantaged communities or practitioners do not have exposure to. So having been that exposed, what do you think should be a preferred mechanism to be able to ensure that there's inclusiveness and transformation in the sector in this area of work? Thank you.
Thank you, Commissioner. At the beginning, I indicated what my background was. Grew up in a rural town, that's all part of my resume, and went to do articles in a law firm in which we had to rely on general type of work. I know exactly what it is to be in a small or medium law firm and reliant upon the type of work that is not regarded as that lucrative. So I've very full understanding where you're coming from with that question. What we are doing, and I don't want to speak about or on behalf of my firm here, because this is my interview. But what we actively do, and which I participate in, is that we recruit the majority of our annual intake of candidate attorneys from university campuses like UWC. In fact, we have a recruitment team who physically visits those campuses, interviews people. We will have a kiosk up there, and students would come and try and find out more about the job opportunities at these firms. So we employ, and our ratios are really quite good. Our intake is in the majority on a year-on-year basis. Our intake of candidate attorneys are in the majority African Black. Then the training that they get, and now I'm just getting closer to my proposed answer to that dilemma. The type of training that you then expose your candidate attorneys to, I think, is crucial. And unfortunately, the big law firms can only employ so many people. The sad reality is that if a candidate, and it could be a very promising person leaving the university, ends up in a very small law firm doing articles, who will not get training in commercial law, who will not be exposed to the type of work that will really enrich that person or enhance the skills to the extent that you become, it becomes even possible for you to represent clients or receive instructions from commercial clients. So what we do is we rotate our candidate attorneys, we give them exposure to all those areas of the law while they are working with us. They get exposed to our clients, and those who become associates and are retained then have that relationship with those clients. And I think little by little we are making inroads in that part towards solving that problem. In fact, so many of those candidates that I talk about now, when they become associates, are snooped up by, they are employed by corporates because they sought after, they went through very good training, and they are appointed as in-house counsel in some instances. And I think we are gradually turning the tide, but the majority of disadvantaged persons entering the legal profession, finding themselves in small law firms, will unfortunately continue to struggle unless there is a kind of a program whereby they get exposed to commercial work. And given the nature of legal practice and the fact that a lawyer acts for a client who may or may not be inclined to show any type of commitment to a transfer of skills to smaller law firm, I think that's going to just something that we're not going to solve anytime soon. The best one can do is where you are, lead where you are, and where you can make a difference. And this is what I've been trying to do. And we definitely provide, I can say with a good conscience, we give that exposure, we give the training, and we do equip people to become competitive in the future. And we are creating futures where they didn't exist previously, but in small numbers, Commissioner.
Thank you.
Thank you, Minister. Chairperson?
Thank you very much, CJ. Good evening, Mr. Barrenson.
Good evening, Commissioner.
I see your focus has been primarily on commercial and insurance litigations. How do you approach cases that would require a deeper engagement with constitutional rights as well as the socio-economic issues?
How would I approach cases, Commissioner? Just to mind repeating the question, isn't altogether.
I was saying that in your practice, in the main, you were engaged with commercial and insurance litigation.
Yes.
Now, given an opportunity to be appointed as a judge at the High Court, obviously you have to be engaged with multi-disciplines, legal disciplines. Now, in the main, the Constitution will come to the play. Now, my question is, how are you then going to approach cases that will require a deeper engagement with constitutional rights as well as the socio-economic issues?
The question is now clear. Thank you, Commissioner. The Constitution, I must perhaps start by saying that the courts and judges are enjoined to enforce the Constitution of the RSA. And in fact, it is their duty under Section 165 of the Constitution to do so. Where cases have constitutional imperatives, and you are presiding over a matter like that, you immediately know when they appear and what they are. Perhaps an example is how I approached and I was the scribe of the CPRI judgment that is in this bundle, where a reading of that case will demonstrate that what was happening here was corporate bullying. A corporate entity trying to bully a single mother, a household with a female breadwinner, and the approach taken to that matter was indeed, and one must bear in mind, Commissioner, that respondent did not even oppose that particular appeal, did not have resources to do so. And yet we found for the respondent in that matter, by placing reliance on those very imperatives, which were blatantly overlooked by the party trying to evict, this corporate giant trying to evict this person from a household. We encounter that very same dynamic, for lack of a better term, when you are faced with these Rule 46A orders, where banks, as commercial institutions, approach a court and want or ask for an order to sell a property in execution because the bond payments are in arrears. Now, while one is aware that the economy must happen, that banks will always be there, and that they must also continue functioning, there is, and this is what the Constitution requires of us, that delicate balance that you must strike. So where there are rights enshrined in the Constitution, you need to recognize them and protect them within the factual context of each and every case that you preside over. It is simply compelling to do so. So even with a background of practicing law in the commercial space, Commissioner, if there are any concerns in that regard, if I'm elevated to the bench, I will not be a judge taking sides with corporates, to put it bluntly, and overlook the constitutional rights that may be violated in a particular matter. I hope that answers the question, Commissioner.
No, thank you very much, Mr. Parense. Thank you, CJ.
All right. It doesn't appear that there are any more questions for you. Oh, there is. Commissioner Mkhanda.
Oh, yes, thank you, Chief Justice. I won't be long. Mr. Barnes, good evening.
Good evening, please.
I won't take much of the time because the matter I wanted to raise with you has been taken up by the JP of the division. What I thought I should bring beforehand
was what I thought it was a good gesture by the court in that matter. This being an unrepresented respondent in the matter, and the court, before it took a decision, thought it proper that they invite an attorney that represented this absent litigant to come and address the court on the issues so that the court would be better placed to make a sound judgment. I think that came out beaming from your judgment. The point that I wanted to raise again to question you about is how would you take the outcome in the matter where you assisted or you were the attorney on record in the matter involving the Wild Coast exploration? Just don't have time to go through it, but where I think the third and the fourth respondent that were assisted by you wanted to do the exploration in the Wild Coast, and the judge ruled that there was no proper engagement because of the language that was used for that specific group, which was Xhosa speaking. Should you become a judge or should you get the appointment into the bench, how important will it be for you that where a group is affected, the language that must speak to that group should be the relevant one, if it's not English and Afrikaans? Thank you, Chief.
Commissioner, I cannot speak Xhosa. When you deal with a matter, and you made reference to sustaining the Wild Coast case, I think that was the one that involved Shell as respondent. If I am to be approached by some of those communities who say to you that we have a direct and substantial interest in this this permit that was authorized by the minister for seismic exploration, and we were not properly consulted, and therefore our rights worthy of protection have been violated. I don't think that I will be at a disadvantage simply because I do not speak the language, Commissioner, because we extensively can make use of interpreters where necessary. And importantly, in that case, it was exactly about lack of consultation in the medium understandable to the affected communities. But I don't see your inability to speak that particular language, be it Xhosa, be it Zulu, to put you at a disadvantage. I'm happy to answer a follow-up question on that, because that's the statement I made.
Through you, Chief Justice. No, it wasn't about you speaking the language. How important it is for the community that at least they benefit. The judgment can be translated and other means can be used so that a decision that affects a community, they are able to at least understand it. Thank you.
Thank you, Commissioner.
Sorry, was the question answered? Or was the question?
I wrongly or rightly assumed.
I clarified it, Chief Justice, what it meant.
I think the Commissioner was satisfied, the CJ.
Oh, thank you. I'm sorry I got distracted. There are many things that are being brought to my attention as I'm sitting here. All right. Mr. Barense, I can now confirm that I have the letter you mentioned.
Yes, CJ.
From the DPP has since been brought to my attention, and indeed it does confirm that the matter was fully investigated and the decision was made that there are no reasonable prospects of a successful prosecution against you, and the police closed the matter in June 2025 already. So you are off the hook on that one.
CJ, the matter that was closed in June 2025, in fact, I wasn't even aware of it, is against those people who were accused. Remember, I merely acted for a witness.
Oh, I see.
There was never a case against me. In fact, that was quite a harrowing experience, and it was something that could potentially have ended my career, CJ.
Yeah.
Anyway.
We've reached the end of your interview, and I just want to thank you for having applied for a vacancy with that court where I started my own judicial career. I wish you all the best, and you're excused.
Thank you very much, CJ. Thank you, commissioners.
Good evening, Advocate.
Good evening, good evening, Madam Chief Justice.
I'm sorry, I don't want to mangle your name. I don't know how to pronounce it, and I hate it when people, don't pronounce my name correctly. So,
Madam Chief
how is it
Justice, if I
pronounced?
may assist, my first name is Ajay, and my surname is Bupchand.
Upchand. All right.
That's right.
Okay, thank you.
Thank you.
It's an unusual name. I've not heard of it before. May we start?
Yes, please.
Or perhaps I should start by apologizing for calling you here at this time of the day. Thank you for bearing with us, and we'll try not to keep you for too long.
Madam Chief Justice, I can only imagine that all of you, and if I could perhaps just greet the Judge President, and I believe the Minister is here as well, that all of you have probably had a much longer and harder day than I have.
That's very kind of you. Thank you. All right, let's go then. You started out as a medical doctor.
That's correct, Madam Chief Justice.
You did your MB, CHB at UCT, practiced medicine in its various aspects for what, 18 years?
Well, yes, about 20, yeah, about 18 years in total.
And then you upped and went and did an LLB and pivoted into an entirely different direction altogether
That's
and
correct.
became an advocate.
That's correct, Madam Chief Justice.
Okay, so you did this LLB with UNISA, and then you also did a domestic arbitration course later on, which you obtained cum laude, and you also obtained a medical mediation, um, mediation in motion, um, a mediation qualification is just too long, in 2022.
That's correct, Madam Chief Justice.
All right. As I understand it, your practice has focused primarily on personal injury, medical negligence, and medical law.
No, that is absolutely correct, Madam Chief Justice, except that if one looks at the numbers, then the numbers weigh heavily towards delictual law, towards medical law, towards, but I've also had the opportunity of doing a wide array of matters in the other fields of law as well, as I have specified both in my questionnaire and in my response to the law bodies that commented on that particular aspect.
Yes. So, how have you found the switch, if I may ask?
The switch from medicine
From
to law.
medicine to law?
Madam Chief Justice, I think one needs to go back to where this all began, and that began in my childhood, when the seeds for both professions were planted. As I indicated in my written synopsis, that my mother wanted me to be the doctor in the family. My father certainly pushed me towards law. He spoke about the great lawyers at that particular time. So those seeds were present, and they never dissipated. So once I had qualified as a medical doctor, I always thought that there was something amiss in my life, and I knew exactly what it was. So I did what I had aspired to during my childhood and during my years of growth and development. And so I enrolled for the LLB degree. I obtained the LLB degree, not expecting to want to practice law, but once I'd obtained the degree, I then considered that perhaps I could be a reasonable trial lawyer, and hence that was when the change came.
That's an interesting story. So, you say in your questionnaire that the first, the early years of your legal career as junior counsel were spent on legal aid, criminal work.
That's correct.
So you did have a chance to do criminal work before you moved on to the other aspects of the law.
Madam Chair, I don't know whether that has changed at all, but we are given opportunities, in fact, exceptional opportunities. We were allowed to defend murderers, serial murderers, serial rapists in those days, when we were allocated legal aid criminal work. So I was very fortunate that I had a reasonable opportunity to do quite a few criminal matters during my early years.
Yeah. You list a whole range of courts you appear in, the High Court, in the Western Cape, in North Gauteng, and Kimberley, the land claims court as then was. So you did land matters as well.
Yes, that's correct.
You mentioned the divorce court, and the Magistrates Court, of course, as junior counsel. And you say you've led juniors in the Western Cape High Court and in North Gauteng, and appeared in the motion court of the Western Cape Division and the Durban High Court.
That's correct.
Let's go to your acting stints as a judge. When did you start acting as a judge?
Madam Chief Justice, I had to wait for that opportunity. I'm a traditionalist and I was not invited initially, but I finally got an invitation to act as a pro bono ad hoc acting judge, and that particular period began on the 1st of September 2023, and that extended to the 31st of October 2024. I was
So
then
you-
given... Sorry, Madam
No,
Chief
I was going
Justice.
to ask if you volunteered your services free of charge.
Yes, that was on a pro bono basis, and I thoroughly enjoyed that experience.
Right. So how long have you acted as a judge?
I then began formal acting appointments, which extended from the 1st of November 2024, excluding the recess periods, up to the 9th of January 2026. During the course of this year, I also spent a month, that is the month of February, completing a part-heard criminal matter.
All right. Have you written any judgments?
Madam Chief Justice, I think I've done well in that respect. There's at least 60 of my judgments on SAFLI.
And in addition to those judgments, you have actually published outside the field of law. You have listed a medical paper.
That's
I'm not
right.
even going to read what is on. That's just Greek to me. And this was a peer-reviewed journal.
Yes, I'll just explain it very quickly. Those were the early days of the HIV infection, and I was employed as a registrar in cardiothoracic surgery at the University of Cape Town, and we had thought that one of our transplant patients was one of the first patients to actually acquire this virus, but it was incorrect. But in essence, we did publish. I was the first author of that paper, but that in essence was what it was all about.
So you've always had a knack for writing.
I feel very comfortable writing. I enjoy writing, and I see it as an expression of myself, and I hope that it shows as such.
You have listed a few bodies for which you did quasi-judicial work. You say you've presided for 5 years. You were presiding officer of appeal panels in terms of Section 91 of COIDA, and you also list a serving on a disciplinary panel for a year, and as a member of the Transformation Committee of the Cape Bar for 2 years, and you also list being a presiding officer, appeal panel under COIDA. So you do have other adjudicative experience beyond these acting judicial stints.
Yes, Madam Chief Justice, I've also had that opportunity, the privilege of doing a lot of work, extracurrial adjudication for the Compensation Commissioner, and over quite a period of time. And then I've chaired other bodies, and I've chaired panels of the Legal Practice Council of recent times.
All right. You have disclosed that a litigant has instituted a defamation action against you, arising from a judgment you co-wrote with a senior colleague in the Western Cape Division.
That is correct, Madam Chief Justice.
I'm not quite sure how to ask you about this, but I'm worried about it, and I'm asking myself what would happen if you were found liable in that matter. What impact would that finding have on your judicial status if you are appointed a judge being found liable for defamation? Is that something we should worry about?
Madam Chief Justice, I fully understand the sub judice nature of those matters, but what I want to bring to the attention of this commission is that that litigation arose out of, during the course of my service as an acting judge. It wasn't myself alone. This matter was co-adjudicated with a senior judge, and the judgment was issued by the court. The particular litigant was not given permission under Section 47 of the Superior Courts Act to sue both myself and the senior judge. He then proceeded to litigate against me alone in another division of our courts without obtaining the permission of that court to litigate against me. He then proceeded to institute a review application against me in another division of the courts, and then he also lodged a complaint against me with the Legal Practice Council. Now, if I could address the question that you've asked, Madam Chief Justice, you must understand that I'm also in this invidious position that up to the 19th of September.
Can I ask you to pause there? I'm sorry to do this to you. Advocate Boshoff, is there something you wanted to raise?
Sorry, CJ, I'm just looking at the report from the Objections Committee. And if it's the matter that I think they deal with, I'm not sure I understand their report correctly, that this is perhaps one that they advised us that we should rather not interrogate it.
Is that so, Commissioner Lepu? Didn't bring that to my attention.
Yeah.
All right.
Because of the nature, and they've dismissed it. Sorry, I'm sorry, I don't. Unless I misunderstand the point of what they say in paragraph 5. Sorry, Mr. Butcher.
Chief Justice, if I can assist, that's correct. The Complaints Committee has dismissed the complaint.
Oh, thank you for that. I'm just being handed something only now. Thank you for that timely intervention, Advocate Boshoff. You need not go any further, Advocate.
Thank you, Madam Chief Justice, but I am willing to expand if you so.
No, not at all. Not at all. Please forgive me. All right, just one last issue from me for now. You will turn 67 in November. Am I right?
That's correct, Madam Chief Justice.
Okay, it might be a concern for some that you wish to join the bench at that mature age when you have a few years left to serve. Would it be fair for your age to be held against you?
Madam Chief Justice, I hope that in my acting stints, and I can only say that the Honorable Judge President of our division may be able to elaborate on this particular aspect. But I do not believe that I've been found wanting at my grand old age in terms of my capacity to work, in terms of my ability to produce quality work, and I hope that that reflects in the number and the quality of judgments that I have written, as well as for the amount of work that I've volunteered over and above the normal work that was allocated to me. Thank you, Madam Chief Justice.
Thank you. And what is your state of health? Well, you are the doctor.
Yes, my personal diagnosis is that everything is fine.
I like that. Thank you,
Madam
Advocate
Chief
Bhuthan.
Justice, if I may, please, I promised myself that I'd do one thing. And if you'll allow me just this few minutes, that I'd like to acknowledge my roots, and I'd like to acknowledge just a few people who made an extraordinary contribution towards my professional development. And if I could just say that very quickly, the first are my parents who sowed in me the seeds to aspire and achieve. A uncle on my maternal side who paid for my medical education over and above that which was not covered by bursaries. A colleague, a medical colleague who entered into a partnership with me when I went into general practice. And then once I got into law, there was, and this issue has arisen in the JSC as to what judges can do to promote transformation. And I had the fortune of encountering the Honorable Justice Erasmus, Nathan Erasmus, in one of my criminal works, in one of my criminal cases that I was involved in, and he asked me as to whether I was getting any civil briefs. And I explained to him that that was few and far apart. And he actually called one of the attorneys that he had known, Mr. Riley, who actually began giving me civil work. And that was my transition, then my transition that was facilitated by a judge. And once I was given the first few cases, thereafter they came very rapidly. So I think I'd be amiss not to make mention of these persons who had such a profound impact on my career development. Thank you so much.
They must all be very proud of you. Are your parents still alive?
No, both my parents have passed on, but I do hope that I have fulfilled all that they expected of me.
Well, I'm sure they see you wherever they are, and they are proud of you.
Thank you for those
Okay.
kind words, Madam Chief Justice.
I'm going to hand over to the JP to put questions to you.
Good evening, Judge President.
Chief Justice.
Oh, before I do that, objections committee. I've not had time to look at this document. I was just handed a short while ago. Is there anything that you need to put to the candidate? Is that what you wanted to raise with me, Commissioner Steinberg?
No, we have nothing to.
Nothing to put to him.
I have a report here, the report of the Objections Committee, that says that there are objections he needs to answer.
All right. Who will do that? You or Commissioner Lepo? Or do you need time to have a look at them, Commissioner? Okay, then you can do it later. Let's keep it going in the meantime. JP?
Thank you, Chief Justice. Good evening, Advocate Bhuthan.
Good evening, Madam Judge President.
Yes, I think I'll start from where the CJ ended. She asked you that you'll be turning 67, and one may ask, why should you be appointed ahead of younger colleagues? What is it that stands out about your candidature that someone who may be seen to have more time, as someone that you may be seen to have less time on the bench, what is it that stands out about you that you would be bringing to the bench were you to be appointed?
Madam Chief Justice, I bring a multidisciplinary background and a specific knowledge in a particular field that could be of extreme assistance to the Western Cape bench, and that is in dealing quite effectively and efficiently with delictual matters, especially matters like the road accident fund, and to deal with it quite speedily as well. As you know, a senior judge has been allocated to case manage these cases, and I believe that I could fit in very easily into that role overnight if I'm appointed. But in addition to that, I do believe that I could be of great value in the adjudication of criminal matters, especially when it comes to the medical aspects of those matters, like post-mortem reports, DNA evidence, etc.
You've done a few criminal matters so far, and the last one you did was in Paulsmoor, at our Paulsmoor court.
That's correct.
How did you find that experience?
Madam Chief Justice, you are aware that there were some teething problems at the Paulsmoor Circuit Court, but in essence, I thoroughly enjoyed every minute, not only of the criminal matters that I did, but of all matters that I've done so.
And what's your view on virtual courts in criminal matters, taking into account Section 158 of the Criminal Procedure Act? Should virtual matters be only for remands and postponements, or should they be extended to trials?
See, I think one of the important aspects of the adjudication, the assessment of a criminal matter is demeanor, is the reaction of a particular accused, and in that respect, I think that virtual hearings may have a major limitation that may impose a difficulty on the adjudicating officer as far as that is concerned.
Okay, and I seen your questionnaire, you say that you have, for admin law and constitutional law, they form only 1% of your practice. Have you encountered any administrative law and constitutional law matters in court?
Certainly I've done quite a few administrative law matters, at least about 7 or 8 in court.
Okay, can you tell us more about self-reviews?
Yes, some of them involved municipal decisions that were challenged. Madam Chief Justice, I recall
maybe
those.
let me be more clear. What is the pathway that is available for an organ of state that wants to bring a review application to set aside its decision to the court?
Sorry, the pathways are certainly PAJA, and where PAJA does not apply, then it is the principle of legality.
So it is PAJA, is that what you're saying?
That's right.
Okay. Okay, let me leave that question for now. If you are seized with a matter where there are a number of defenses at play that have been raised, but you are of the view that one of the defenses can dispose of the matter, but there are other defenses that are there, how would you deal with that in your judgment?
Sorry, is this in an administrative law matter?
No, generally.
Oh, generally. Well, I would certainly list those defenses, but if there is a particular defense that disposes of that matter, then that certainly would be the defense that
I think the question I'm asking is, as a court of first instance. As a court of first instance, are you at liberty to say, this is dispositive and I don't need to deal with the other defenses? Or are you supposed to deal with all the defenses regardless of your view of that one defense?
No, I would deal with all of the defenses to evaluate them.
Okay, I've got other questions, but in the interest of time, CJ, I would not ask because the last time okay, I have one. Can I just at least ask one question? You've written a judgment where you articulated just the importance of understanding Rule 67, capital A,
Sorry, the importance
of Rule 67, capital
Yes.
A. Can you
Yes.
explain that more for us?
Yes, in essence, that is relates to the costs that could be awarded, and that specifically addresses the costs of advocates. And in essence, there is a scale that is applied to the fees that advocates can seek. And that is the scale is scale A, scale B, and scale C. And in essence, the ordering of costs, well, first it will deal with the normal principles of costs, whether that is party and party or any other principle, and then that one then deals with the costs that would apply to council's fees. And that's in essence what it deals with. In fact, this rule was specifically developed to address that particular aspect, to keep advocates' fees in control.
The other questions I wanted to ask relate to possibly what the objections committee is going to be dealing with. Maybe I will ask a follow-up question after that.
Thank you. Thank you, Madam Judge President.
Advocate Boshoff?
Yes. Sorry. Thank you, Chief Justice. Yeah, so I'm also in the same position as JP because I wanted to ask something about the cost, but I just need guidance on whether we defer to the objections committee to first deal with it and then ask follow-up questions.
Maybe let's have them first deal with it. Are you in a position to do so now?
I'm not part of that committee, Chief Justice.
Is Commissioner Kane not?
No.
Oh, no, okay. Then it's her responsibility. All right. Why are the mics suddenly ring? Okay, the objections committee will have a bash at it, then you can do your follow-up questions.
Mr. Bobchan, we've got the objections committee has received 3 complaints against you. We have dismissed, I confirm. The one submitted by attorney Zahir Omar has been dismissed. So besides that one, there are others. The GCB says that you believe that the parties after the close of pleadings could obtain expert reports and return to court within a matter of 4 months. And they say that that displays a lack of knowledge of managing complex trials. Would you like to comment on that?
Madam Chief Justice, this was a case that was allocated to me to hear a special plea. The parties were not ready on the date or the scheduled date that matter was allocated, and they asked for a postponement, and they asked me to keep the file. All that I did was that I ensured that the matter was progressed. But what then subsequently happened was that they returned to the case management judge, and when the matter resumed, that was a few months later, I was informed that the matter was not going to progress. They hadn't informed me that the matter would not progress on the date agreed, and I'm clear in my mind that all that I did was to try and progress the matter and to ensure that we did not lose further court days as far as that matter was concerned. In fact, in total, there were 2 court days that were wasted.
And particularly, they say, they specifically mention that the parties could close proceedings and then obtain expert reports.
I don't understand that, Commissioner.
I'll go on to the next one. Advocate Fitzpatrick of the Cape Bar said that You were rude and discourteous as an acting judge. You interfered with the manner in which she was running the trial and made pejorative comments about the competency of herself and and the junior, resulting in a recusal application being made. Would you like to comment on that one?
Yes, I did. I did answer that comprehensively in my response to the complaint. I think it's important that one looks at the particular circumstances. I was assigned to hear a medical negligence matter, a reasonably complex medical negligence matter. The matter had proceeded and we had heard two witnesses. What I observed was that counsel were experiencing difficulties in cross-examining the witnesses, and that was not made any easier by the fact that the opponent, who was a senior counsel, was raising numerous objections. Now, I made no adverse comment in court. All that I wanted to do was to establish from counsel as to whether they were what was the basis of the difficulties that they were experiencing. I asked counsel alone, that's counsel from both sides, to see me in chambers, and this was where it was raised. Now, I understand that two practitioners were offended by my approach. I apologize profusely to them, but the intention was purely to understand what was their difficulty and if there was anything that I could do to assist them. Unfortunately, that was what happened, and two of the practitioners took offense. They asked for my recusal. I heard the recusal application and I dismissed the recusal application. But I want to emphasize 2 points. And one was that I at no stage wanted to belittle or to insult counsel, hence the conversations took place in chambers. And secondly, there was also an accusation that I may have treated them like that because they were women. That is so unfortunate. I've never ever viewed practitioners from a gendered lens.
What of your comments, she says, that you told them that they should withdraw from the case and brief a senior? Now that was one of the main submissions, one of the main complaints you made against her.
Madam Chief Justice, my recollection is very clear. All I said was one of three things. One was that if you are experiencing difficulties, then the practice at the bar is that you consult with a colleague who is well versed in that particular field of the law. If you are still experiencing difficulties, then you should ask your client to consider bringing in another counsel, a more senior counsel, not senior counsel as such, but a more senior counsel. So at no stage did I tell them that they had to withdraw from the case. There's absolutely no ways in which I would have said that. But all in all, I want to say, and I want to emphasize this point, that there were practitioners who were offended. I did apologize on quite a few occasions to them, and I had hoped that they had accepted it.
The third criticism is that you made creative use of cost orders, and that was to try and push the transformation agenda, it seems. And the comment you made in court was that had some other counsel been instructed by the state organ, then maybe you would have granted cost order in favor of them.
It was an obiter statement. I want to emphasize that the matter was JVR versus the Minister of Home Affairs. It was made entirely as an arbiter statement. It had absolutely no impact on the eventual order on costs that I granted. Madam Chief Justice, the situation was as follows. I was adjudicating a matter involving an application for a late birth certificate. The applicant employed two counsel for a matter that could have been dealt with and disposed of by the junior counsel. The junior counsel was at the bar for less than 5 years. The more senior junior counsel had been at the bar for about 33 years. They were both of monochromatic race. They were both white males. Now, firstly, I felt that this was a top-heavy legal team that was briefed for the magnitude of the matter that I had heard. Secondly, that when it came to costs, they motivated that the senior junior get, in terms of 67A, get their fees paid on scale C, and the junior with less than 5 years experience should have his fees allowed on scale B. Now, for the nature and complexity of that matter, that was not justified. I did make the observation that in a situation like that, this is the arbiter observation that I had made, and this is a matter that goes to briefing patterns, that had they chosen counsel and had taken transformation into account, a court may have been more amenable to granting a better cost order than what was conceded by their counsel. Their counsel conceded that that matter could have been settled by a junior and costs could have been granted on the A scale for one counsel alone. Now, when I made that single sentence statement in that judgment, it was to recognize a problem that's inherent as far as briefing patterns are concerned in the Western Cape, notorious in the Western Cape Division, but I suspect that it is just as prevalent in all of the other divisions as well. I do know that the issue of briefing patterns has even been raised in this body as well. I am also aware that this is a major problem for the judiciary as a whole. So when I made that arbiter statement, that was taking into account not only what I was presented with, but it also took into account a few other aspects. And that goes to, firstly, the transformative nature of the Constitution that judges need to be aware of. Secondly, it goes to the question of equality when it comes to briefing patterns. Thirdly, the context regarding the state entity that was involved was that here was a party that had briefed two counsel and they expected the state to pay for that particular privilege. So they expected the state to pay for a senior junior counsel as well as a junior counsel at a favorable rate. And my understanding is that certainly the state has to assist the transformation process, but certainly it cannot be brought in to assist the perpetuation of old practices that maintain the past briefing patterns. And that, Madam Chief Justice, is my response, my comprehensive response to that particular judgment.
Thank you, Chief Justice.
Thank you, Commissioner Jovan. Back to you, JP then.
Thank you, Chief Justice. I'm just going to ask one question that relates to the incident of you being said to have belittled counsel.
Yes, Madam Chief Justice.
We talked, I think this was brought to my attention, and then you and I had a discussion about it. Can you explain what you did after that?
Madam Chief Justice, as I explained to you, I was really, it really affected me. It had quite an impact on me, and this is, I'm referring to the counsel who implied that I had belittled her. What I want to emphasize is that I apologized to her in chambers. I even apologized to her when I delivered the recusal judgment. I volunteered this particular incident to you because of the impact that it had on me, and that I then wrote you a letter. You asked me for permission to forward that letter to the Bar Council. But that particular aspect of that letter was volunteered by me. I hope I'm answering your question, Madam.
Yes, you have. Thank
Judge
you.
President. Thank you so much.
Thanks, Chief Justice. Other points have already been covered.
All right. Thank you, JP. Advocate.
Thank you, Chief Justice. Advocate Bookchan, just on the costs issue, I'm a bit confused because I read the extract from the judgment, and I understand from that extract what you're saying here, that the scale that they were asking was unreasonable.
Yes.
What I'm struggling is to reconcile that then with your response in the questionnaire, where you say, in essence, the court can utilize the cost order to essentially, my understanding is, express its displeasure with the makeup of legal representation before it. Now, you'll recall there was a matter involving black economic empowerment case.
Yes.
And Judge Mthatha, I think, I hope I'm pronouncing that correctly, called for representations from the legal teams. Now, I think in the debates that followed from that, I think we can agree that it's naive to think that the judiciary should stand out of the water and essentially keep quiet about these things. But would you not agree that utilizing costs, which is part of the judgment ultimately, to essentially direct where a court thinks briefing patterns should be going, does that not directly offend the fundamental principle of equality before the law, equality before courts, the expectation of being treated fairly and equally? Because there are mechanisms which you've already expanded on to have dealt with the matter before you. I don't think anybody is disputing that, as I understand you describing the matter, that the scale and the costs for two counsel is outrageous. But then the solution is issue it, cost for one counsel, scale A, but I cannot, because you understand the risk is obviously if courts were to start doing that with cost orders, what on what basis would one not then perceive courts to also be potentially arbitrary or biased in the merits of the matter, based on the makeup of legal representation or even parties before it? It would strike at the fundamental heart of a litigant's expectation that I come to court, and if I win, within the confines of the law, I should get my costs, and then we can have a debate about what that entails. But this is directly punishing a successful litigant because of their choice of counsel. And to me, that seems to deny them essentially equal treatment by that court. Or I'd like to hear your view on that.
Commissioner, thank you for that question. I'm just intrigued by all of the consequential effects that have been placed upon a statement that is made in a judgment as an arbiter statement. The nature, one needs to go back to the nature of an arbiter statement. An arbiter statement is not precedent setting. It creates the situation that needs to be addressed. And I see inherent in your proposition to me is that you accept that these are situations that need to be addressed. There's been attempts at addressing them. And I want to emphasize again, what I was doing was that I was observing the court before me, the representation before me. I made that arbiter statement, and if we go back to the history of cost matters where there's been deviation from the common law principle of as far as costs are concerned, like BioWatch, they all arose, like from the Carmichael matter, they all arose from comments that were made arbiter. The question that the judiciary has to ask itself, the question that the JSC has to ask itself, the question that I humbly believe every judge should ask themselves is, how do we address and rectify those imbalances that have been identified? Could it be through a court looking at the peculiar representation before itself and taking into account, especially when it involves the state as the opposition party, as to whether that may not be an opportunity to address this imbalance, this problem that has beset the judiciary since the new constitution has come into effect. That, I want to emphasize, was the deliberate intention of adding that arbiter statement in that judgment. And I hope that another court would take that particular aspect and then apply it in the proper way. Invite, in a particular, the appropriate case, invite counsel to provide argument and to test what is the ambit of that particular arbiter statement. Thank you, Madam Chief Justice.
Sorry, just further.
Yes,
Yep, Advocate, I take the point. I understand what you're saying, but I still struggle to reconcile that then with because what you're saying in your questionnaire is essentially that, the creative use of cost orders to deprive legal teams that refuse to represent the demographics of the country. That is suggesting going beyond Overton, actually utilizing the rule to essentially punish or express a court's displeasure with the makeup of legal representatives before it. I take the point that you may have raised the issue in that matter, Obito, because it became moot because of, on the merits of it, the costs were inappropriate that were being sought. But what you are suggesting is that another court should go further and actually apply the rule in such a manner. And I'm saying that that would be an affront to the constitutional protection, to equality and fair treatment and equal treatment by our courts. Because costs, as you would know, is no small matter, especially when people are litigating, on the skin of their pants. It has a serious impact.
No, I must say, I do apologize that one must accept that it is the person who is reading a particular statement that may interpret it in a different way. I hope that by explaining what I've explained today, that reflects what I had intended, and I take I take into account absolutely and completely everything that you've said. And I do apologize if it was misinterpreted or misinterpreted in any way whatsoever.
There's no need to apologize. That's why we discuss.
No, but I think it's important that one communicates, that one takes into account that there are people who are interpreting it, and they may very well misread what your intention was. Thank you, Madam Chief Justice.
Thank you, Chief Justice.
Is the follow-up? All right, go ahead. Yeah.
Thank you, CJ. Good evening, Mr. Bupchand.
Good evening.
Did I say it correctly?
Absolutely correct. Absolutely correct.
Yes.
Correctly. Good evening, sir.
Yes. Just to follow up on the two issues that were raised with you. I do appreciate the fact that you wrote to the Bar Council to apologize for what has transpired. But I'm just concerned that now in this body, you seem to suggest that the two council that had that problem may have lied about what you said.
No, absolutely not.
They did not lie. They did not tell a lie. Or to us here, when they say you suggested that they should rather get some senior advocates who would understand, appreciate the issues in that matter.
The only issue was when they said that I asked them to withdraw from the case.
Yes.
And that I'm clear in my mind that I never did that.
You never said that.
I never said that. I can't take that any further.
But they say you told them, you suggested to them that they should withdraw from the matter.
I did not suggest to them that they withdraw from the matter.
Yes, what I'm saying is now it's a dispute of fact. The position in which you were as a judge might affect their professions very adversely. I don't know if you appreciate what I'm saying.
No, I fully appreciate. Fully appreciate what you're saying.
I understand your explanation and your apology with regard to weaponizing the cost orders, and you apologize for that. Well, weaponizing is the wording I'm used, but they say you are creative here. But these orbital remarks, I don't think it's advisable for judges to make such orbital remarks. Right now, you are telling us that Judge Erasmus told or instructed attorneys to brief you on criminal matters. I don't know if he had this permission to be uttering such remarks.
I'm sorry, Commissioner, I didn't hear.
You said to this body that Judge Erasmus, if I heard you, instructed or told attorneys to brief you on criminal matters.
On civil matters.
Civil matters.
That's right.
Yes. I don't know whether that will occur well with Judge Erasmus that he did such a thing.
No, he suggested to an attorney, Mr. Riley, that I should be given the opportunity to do civil matters. And that is what I had appreciated.
Thank you, CJ. I won't take it further than that.
Minister?
Thank you very much, Minister. CJ, good evening, Mr. Advocate Boopchand.
Good evening, Commissioner.
We were taken to court by Society for Protection of our Constitution. Part A and Part B of the matters. The issue there was that the applicant was in court to get immediate suspension of your acting as a judge and compel the minister to put in place criteria and vetting procedures for acting judges. The matter in terms of merits was never processed, but the decision, it was because you were no longer acting.
I'm sorry.
And you were no longer acting. So when Judge Tolman dealt with the matter, he dismissed it on the basis that you are no longer acting.
That was
And-
the part A of the relief.
Yes,
that was
the Part A. But the Part B remained with me in terms of criteria of the people that we are appointing as acting judges. And the question I have is that, what risk does JC face should it appoint you in light of this matter?
I have addressed each of the critical aspects in that particular application, and I have provided the information that the organization had identified, and I hope that I've addressed it adequately. I've addressed each and every one of them, and each and every one of them sufficiently for this body to make a decision on that aspect. And I want to say with all humility that there is no risk.
Okay, thanks. And then let's go to your CV. On page 22, you are saying you were admitted on the 1st of November 2002 as an advocate of the High Court Western Cape Division. And then you did your pupillage, Cape Bar, 1st January 2003 to 30 June 2003. Is it possible, or is it me who do not understand the
I'm
system?
sorry.
I understood that the pupillage comes first before you get admitted.
That's correct. So in essence, if I could clarify exactly what happened, was that I was admitted as an officer of the court, as an advocate of the court in November 2000. That usually predates the pupillage. I then did pupillage from the 1st of January 2003 till June, and thereafter pupillage was a precondition to becoming a member of the Cape Bar Council. I hope that has clarified that aspect.
No, I did. Thanks. Thank you, CJ.
Thank you, Commissioner.
Thank you, Minister. Any further questions for this candidate, commissioners? No? All right. That's it then, Advocate Boopchand. We've reached the end of your interview. Wishing you all the best.
Madam Chief Justice, if I may say, it's been an absolute pleasure to make your acquaintance and the acquaintance of the other commissioners. I thank you for giving me this opportunity. Thank you so much and good night.
Thank you. You're excused.